As you know, yesterday we were asked twice how many people wear smartwatches, things of that nature. Almost everyone raised their hand. As you also know, um, these things, these most popular Internet of Bodies kind of things, are not covered by HIPAA. And so we are starting out the day talking about HIPAA, what's covered, what's not, kind of all the complications there. And to that end, I would like to welcome Kirk Nahra. He is he's the co-chair of cybersecurity and privacy at the law firm WilmerHale. He specializes in healthcare, compliance, data breaches, de-identification issues, and also works on behalf of insurers. So he has a lot to share with us today. And so I will let him speak for himself, but please join me in welcoming Kirk Nahra.
Thank you. Pleasure to be here this morning. I've been working with healthcare reporters for about 32 years at this point. I am not going to ask how many of you were not alive at that point, but I've enjoyed recently, I got a call from a reporter I've known for many years about a disability rights issue, and I was able to send him to my son for my son's comments. He works in that area. I had another issue from a reporter dealing with a healthcare security breach at a prison, dealing with prisoner health data, and I was able to call my daughter and get her advice on what I should say to the reporter about that, because she's a JD PhD student on mass incarceration issues. So lots of times these issues come up. So let me tell you what I want to try to do today. I have prepared materials, as you'll see on the slides. I'm happy to stop at any point, so don't feel like you need to wait till the end. I'm happy to go through all this. I guess my major goal today, I'm not sure how far you got into the nitty-gritty of this yesterday. It sounds like a little bit, but not too far. I want to explain why the law is the way it is at this point. There's an important history. I want you to understand why, when you see on social media somebody complaining, usually in large capital letters, about a violation of their HIPAA rights, usually misspelling HIPAA, why they are wrong. I want you to understand that. It's not, there's a logical answer and an explanation if you understand the history. It's not otherwise logical, which is why people get it wrong so often. So I want to give you the sense of that background, give you a sense of how that works in today's healthcare system, in today's society. That's actually an important difference. The laws primarily are designed for the healthcare system. Healthcare is not only the healthcare system, as you'll see, so that's one of the complications today in the legal system. We'll talk about a couple of the important developments that are going on. And as I said, at any point, I'm happy to take questions or comments or anything else. I have been doing this for a long time. I've been involved in healthcare privacy specifically, essentially since it started. Again, so there's a benefit from just longevity in terms of seeing all the history. So I know this is a healthcare program rather than a privacy program per se. If you are interested in privacy issues, I think the healthcare structure in the United States is the most, I use the word evolved, I don't know if that's a perfect word, but most evolved privacy structure that we have in the United States, the most history, the most guidance, the most impact, the most enforcement, just the broadest impact of those rules. It's also a really interesting public policy example. You know, when we're having a debate about a national privacy law at this point, and one of the major questions involves, you know, if you're online or you're at a website, you're at the Gap, you're at ESPN, you're at Facebook, what are your rights as a consumer versus what are their rights as a business? And that's sort of a one-on-one, your rights versus their rights. In healthcare, it's a much broader discussion. There are far more interested stakeholders in what goes on with healthcare data. We have the government in multiple roles, as a healthcare provider, as a healthcare payer, as a regulator, as a tax collector. We have taxpayers in general. We have patients in general. We have employers. So I mean, there's just a whole bunch of other people that have an interest in healthcare data that goes beyond most privacy debates. I will focus on HIPAA as the single most important element of healthcare privacy law. At the same time, what is the most interesting part of healthcare privacy law at this point in time is what's not subject to HIPAA, or how HIPAA connects to these other unregulated areas. Lots of confusion about how HIPAA does work, lots of confusion about where it does not apply. So the HIPAA rules, set the stage in a minute for that, have been essentially in place for roughly 20 plus years at this point. They formally required compliance in April of 2003. We'll have some anniversary, I suppose, next spring. It is a standard that at this point in time, where it applies, generally works well for both industry and consumers. That is not true of many privacy laws, right? There are privacy laws that are too weak for consumers or too burdensome for industry. It tends to be a zero-sum game in lots of laws. That's not true here. I want to explain that because it's an important way of thinking about privacy rights in the healthcare area. We are certainly seeing increasing challenges within the healthcare system about how the rules apply. We'll go through a couple of those examples. And as I mentioned, the real issue and the real fight and controversy at this point is in situations where HIPAA does not really apply. All right, when I teach this to students, I say that the most important thing I will teach them is how to spell HIPAA. I get something at least once a week from, usually it's a vendor, trying to convince me to buy their HIPAA services, and they misspell HIPAA, And I say to my students, I said, look, it's a little bit of a joke, but get it right, because if you're a young lawyer and you turn in a memo to your boss on your first week that spells HIPAA wrong, they're not going to listen, they're going to be skeptical. You should think the same. If you get that wrong in your story, you're all of a sudden not credible, even if the rest of the story is right. So it's HIPAA. I ask my students to find me a second P in the name of the statute. They cannot do that, obviously. But it's important, and the reason I emphasize this, it's important to understand what the statute is. Health Insurance Portability and Accountability Act. The P is not for privacy. And so it's this background, I'm going to do a little bit of detail on this just because it's really important. The background had nothing to do with privacy. This law was created because of a problem we had in the health insurance system in the mid-90s. If you were at a job and you wanted to move, where you got health insurance, most people still today get health insurance through their employer. If you were at a job and you wanted to move to a new job, and you had any kind of preexisting medical condition, it was going to be very hard for you to get health insurance at the new employer. So that created this artificial restriction on moving jobs. And so Congress was concerned about that. And so Congress wanted to create a fix for that issue. We called it portability. That's the ability to take your health insurance essentially with you from one employer to the next employer. You couldn't get insurance at the new employer, but you could continue your old insurance. You had to pay for it, but you could continue that insurance that you had at your old employer even though you didn't work there anymore. That was portability. That went through Congress. There was essentially unanimous support for that idea. Hard to imagine today, but that piece of the bill passed unanimously. One of the things that Congress does when they have an idea that everyone agrees with is they like to throw, this is a technical term, other crap into the bill. So they started piling other things into this piece of legislation that became the HIPAA statute. One of the things they came up with is called administrative simplification. This is, again, the very beginning of the internet era. More and more of the healthcare system is moving to being electronic. We had at the time, if you went to the doctor had a paper form that they would mail in to the health insurer, and the health insurer had a paper form that they would mail back, and every doctor had their own form, and every hospital had their own form, and every insurer had their own form. Congress basically said, we're going electronic, we have these computer things, we have this internet that we don't really understand yet. What if we came up with a standard form for computer transactions? So if a doctor submitted a claim, it would be on a standard form, a standard electronic form. And the insurance company's response would be on a standard form. Perfectly fine idea. We can debate whether it worked and how much money it saved, et cetera. But the idea was be more efficient, save money, be more accurate, et cetera. Great. Still aren't at privacy. Then Congress basically said, we're going to make all this we're going to make all this information electronic, and you can send it at the push of a button. Maybe we should think about privacy and security. But if you read the HIPAA statute, that's essentially what it says about privacy and security, is we need to think about this. And so in the HIPAA statute, Congress gave itself a 3-year deadline to write a healthcare privacy law. I don't know how many of you are congressional scholars. Anyone want to guess what happened at the end of that 3 years? Nothing. Not a single bill even got to a congressional committee. So Congress has one skill, which is recognizing that it's not going to meet its own obligations. So essentially it said, if we don't pass a law in 3 years, we're going to make the Department of Health and Human Services write a regulation. So when we talk about privacy and HIPAA, what we are actually talking about is a regulation written by the Department of Health and Human Services. People say, oh, the HIPAA statute says, the HIPAA statute doesn't say anything about privacy and security. We have the HIPAA regulation. But the key thing to understand is, again, how we got there. And then the next step, that's really the critical step, is that the only instruction that the Department of Health and Human Services had in writing this regulation was who could be covered by the regulation. No other substance to that. And the who could be covered was defined not by privacy, not by security, but by the entities that were involved in portability and standard electronic transactions. So for example, life insurers. Life insurers have tons of healthcare information about their customers. If any of you have applied for life insurance, you need to give them every piece of medical information that exists about you. But because you don't take your life insurance with you from one employer to the next, life insurers aren't allowed to be subject to these privacy rules. Same for workers' compensation, same for disability, same for auto insurance where you have accident coverage. So if you weren't involved in portability, you're not subject to these rules. You weren't allowed to be subject to privacy rules. We also have what's called the Marcus Welby exception. Anybody know who Marcus Welby was? That's an age test, but Marcus Welby was a television doctor in the 1970s, I think late 70s, in rural Nebraska or something, and he would pay a house call on the family, and he would take Sally's temperature, and he would help little Timmy with his homework, and he might help the parents patch up their marital troubles, and then he'd hand them a bill, and they'd give him a chicken or something like that. Congress didn't want to make Marcus Welby have to buy a computer. So the way the law works on standard transactions was, if you submit standard transactions electronically, they have to be standard, and then you're subject to the rules. But if you don't submit standard electronic transactions at all, you're actually not subject to the privacy and security rules. So we don't care that much about Marcus Welby. There aren't that many Marcus Welbys at this point. But as you may know, there are lots of healthcare providers and other entities in the healthcare system who don't bill the insurance system for their services. You might go to a doctor who says, I'm happy to treat you, I'll do whatever you need, you'll pay me at the end, I'll give you a receipt, you can submit it to your insurance company, but I don't deal with the insurance companies. There's lots of those people. They are not subject to the HIPAA privacy and security rules because they don't submit standard electronic transactions. That's probably the easiest thing to think of when you think of how illogical some of HIPAA is. It makes no sense whatsoever from a consumer perspective to say that your privacy rights depend on how your doctor bills. But that's what we're stuck with because of the way the HIPAA statute was written. So in the HIPAA statute, the people who are subject to the HIPAA privacy and security rules fit 3 categories. They're called covered entities. First is a health plan. That is health insurers. Not life insurers, it's not disability, it's not workers' comp, but it's health insurers at the payment side of the healthcare industry. Aetna, it's United Healthcare, it's Blue Cross Blue Shield, it's Medicare, it's Medicaid. It's also employer-sponsored group health plans, which gets complicated. We can talk about that later. That's obviously the key thing, right? When you had insurance at your old employer, it was part of an employer-sponsored health plan. That's exactly what you were taking with you to the new insurer or to the new employer. It's also healthcare providers, doctors, hospitals, pharmacies, et cetera. There's a variety of other companies that fit that. There are some interesting issues now as technology and medical devices and things like that get more sophisticated. Some of them meet the definitions of healthcare providers, but it's only healthcare providers who submit standard electronic transactions. So lots of these new technologies don't necessarily interact directly with the insurance system, so they may be collecting data. They may have obligations, but they're not necessarily subject to the HIPAA rules. There's also something called clearinghouses, who are essentially the entities who would take a non-standard electronic transaction and convert it to a standard transaction. They're not that important in the big system. Every once in a while, because they have lots of data, actually, they're the middlemen on these transactions. They actually have a lot of data. They don't tend to be that important. There aren't that many of them. We also have something called business associates. Again, HHS, Department of Health and Human Services, sits down with a blank piece of paper and is instructed to write a privacy rule. The only thing on the piece of paper is who can be covered by it. One of the first things that HHS realized was that hospitals and health insurers actually use vendors. Who knew? But they realized that they couldn't regulate the vendors at all. They had no authority over the accounting firm or the analytics firm or the technology firm or the law firm who worked for the hospital or the health insurer. So HHS made up this concept of what's called a business associate. Think of it as a service provider. They realized they had no authority to regulate them directly, but they did have authority to regulate the hospitals and the health insurers. So they put an obligation on the hospitals and the health insurers that said essentially, if you want to use a vendor, you have to have a certain kind of contract with the vendor before it's allowed. And so they created this idea of a business associate agreement that made these vendors subject to the HIPAA rules by contract. And so for about 10 years, that's how HIPAA worked. All those service providers had contract obligations, but the government couldn't penalize them if they did anything wrong. They could have their contract terminated, but that was the only remedy. Going back about 10 years ago now, Congress passed a different statute at the beginning of the Obama administration, the economic stimulus bill that was passed at that point, that changed the statute to make those service providers subject to the law directly. So if you're an accounting firm working for a hospital, you're a technology firm working for a hospital, you've always had a contract with your customer. Now you are subject to the law directly as well, subject to enforcement by the government. But because of that scope, I want to spend a couple minutes on who's not covered. Pharmaceutical companies. They have tons of data. They're core to the healthcare system. They've always been an important part of thinking about privacy in the healthcare system. They are not themselves a healthcare provider. They are not themselves a health insurer. They are not themselves working for either the health insurer or the healthcare provider. So they're just not subject to these rules at all. Employers in general. Huge issue today with things like COVID. When you go and your employer says, I need your vaccine card and I need your COVID history, and you give it to them, nothing to do with HIPAA. When you have an accident at work, when you have a Family Medical Leave Act claim, when you have a doctor's note for why you missed work, none of that is covered by the HIPAA rules because that's an employer being an employer. We have this little segment for the healthcare benefits plan, but that's really separate, and most of your employers hire somebody to take care of that. They hire a health insurer to take care of that. Universities, generally not covered. We've had some interesting issues, maybe particularly relevant to your topic, broader topic today. Student health clinics at universities generally are not subject to HIPAA. First of all, they may not bill insurance at all, and there's a separate law for educational records, and most of the student health clinic records are under that law instead. So we've had some interesting situations where a couple of universities, for example, have been sued over their handling of sexual assault reports. And in a couple of cases, the universities have gone to the student health clinic and been able to obtain information about reports of sexual assaults. If the report of sexual assault had gone to the hospital down the street, the university would have never been able to get that information. But because it was a student health clinic subject to the FERPA rules, they were allowed to get it directly. Yes? Okay. Yeah, they have because it's an educational record. The FERPA law on educational records basically limits what the university can do and who they can disclose it to, but it doesn't limit their ability to get it in the first place. It's sort of their records. So that's a situation where, because we have different laws that apply to the same information, the student who reported a sexual assault to the local hospital has HIPAA protections, which in this case were better. The person who reports it to the student health clinic doesn't have HIPAA rights, have FERPA rights, which don't protect them vis-a-vis the university. So again, that's just some examples of where this coverage is limited because of the HIPAA rules. We'll come back to that and we'll talk about some of the important elements of that. Now, when you're writing the HIPAA rules, this is a key policy choice that I want you to understand. HHS had two goals in mind. They wanted to provide important protections for individual privacy. At the same time, they wanted the healthcare system to work. So there are lots of public policy choices in the HIPAA rules that are designed to balance privacy and a working healthcare system. There are conscious choices written in the rules. You can agree with these choices or not agree with these choices, but there are conscious choices written into the rules that are designed to draw a balance rather than to write rules solely to protect patient privacy. The biggest example, most important example, that's really the core principle of all of the HIPAA privacy rules is where your consent is needed as a patient. And essentially, the premise that HHS had in writing these rules was that they wanted to make it easy to do normal healthcare things and harder to do things that weren't normal or typical or common. So they've written into, and one of the choices there, one of the public policy choices was, if we gave you more rights, privacy rights over the normal things, that would provide incrementally better privacy protection, but it would result in a less effective, less efficient, much more expensive healthcare system, which is not only bad for the healthcare system, but it's bad for most consumers. So that was a choice that was written into the rules. The idea was, if we had better privacy protection, that would be bad for the system. So there are three ways that a hospital or a health insurer can use and disclose your personal information. The core one is for the normal healthcare purposes. Those normal healthcare purposes are defined in the rules. Again, you can quibble with the definitions. You can quibble with the concept, but you can accept the concept and still quibble with the definitions. Treatment, payment, and healthcare operations, which is essentially the administrative activities of running a healthcare business. You go to the doctor, you expect the doctor to use your information to treat you. You expect the doctor to want to get paid. It's okay for the doctor to want to get paid. You expect the doctor to send it to the insurance company. You expect the insurance company to do their job and pay the claim. You may or may not expect that the hospital has to have an internal accounting department and an IT department and other stuff, but that's the administrative operations. Those things, those normal activities, your consent as a patient is assumed by the law. It's just automatic. That's a choice. Think about the alternatives. One would be you have to consent for all of that. You go to the doctor says, I need your consent in order to use or disclose your information for treatment, payment, healthcare operations. You say, I do not consent. The doctor says, thank you very much, I can't help you. Sort of silly to do that, go through that charade a million times a day. Or the doctor could say, here's a list of everything we're going to need to do with your information. It's 1,000 things. Check a bunch of boxes. You tell me what it's okay for me to do out of the 1,000. And your list is going to be different than your list, is going to be different than your list, is going to be different than your list. And none of you are going to have any basis to make that decision. And that's going to result in a much less effective healthcare system. Gave you more privacy rights as an individual to control, but that control is illusory and not effective and not efficient for the overall system. So that's the choice we made. HHS made, I shouldn't say we made. That's one category, that's the most important category. There's also a set of purposes where the people writing the rule said there's an important public policy purpose. We want to facilitate disclosures in that area. Public health is a good example. I used to use a patient with Ebola as the example. Patient with, gets to the hospital diagnosed with Ebola. Public health law says you report that to the public health authorities. It would be really odd if you had to ask the Ebola patient, is it okay if I disclose the fact that you have Ebola to the public health authorities? The whole point of that is to make sure the public health authorities know. So they don't make you ask for the consent on that. There are provisions dealing with litigation and dealing with investigations and a variety of other issues that come up that are public policy goals where your permission is sort of just not relevant. Then we have situations that are not common where your permission is explicit and required. So let me give you two examples to fit this in context. You go to the hospital, you have a rare disease, hospital cures you. Hospital comes to you and says, we would like to tell your story on our website. We think other patients would be inspired, would know there's possibilities there, maybe selfish of the hospital too. I mean, they may want to just promote themselves. That's not normal, right? Normally you don't tell somebody's story on their website. But they're allowed to ask you. They can't make you agree. They can't threaten you. They can't withhold treatment. And you're allowed to say no. But at the same time, you're allowed to say yes. If you say yes and you give what's called your authorization, specific informed permission for that one thing, they can do it. Another example, you are about to be drafted in the NBA or the WNBA. Team's about to pay you $10 million. They say, before we pay you $10 million, we'd like to know that that ankle you broke a year ago is healed, so we need your medical records. You would go to your doctor and say, you have my authorization to disclose my medical records to the basketball team. Normally, the doctor can't just send the records to the basketball team. But you're allowed to tell the doctor to do that, give your authorization for something that's not common, typical, normal, expected. So that's how consent works in the HIPAA system. Again, it's the best example, by far not the only example. It's the best example of making a public policy choice to support both privacy rights and the operation of the healthcare system.
Could we take a break here and just see if there's any questions?
Yep, sure, absolutely. Yeah, and please don't hesitate. I mean, jump in any time. I know most reporters are so shy. Sorry. Yes. Say again?
What does FERPA stand for?
Federal Educational Records and Privacy Act, I think. It's what governs educational records certainly at the university level, in a lot of high schools, mainly public high schools as well.
You bring up some good points. I was thinking of a story that I had done years ago. And an individual I interviewed told me that he felt like he was discriminated because he was forced to disclose some serious medical condition. My editor and I were going back and forth because I know, employers, they do have the right to ask you, do you suffer from any serious medical condition? Can you kind of dig into that a little bit more?
Sure. So forced is an interesting word, So there's a couple of contexts where that could come up. So if the employer says, I don't want to hire you, I don't want to hire you if you have diabetes. I'm making that, That has nothing to do with HIPAA, first of all. 100% not HIPAA. That doesn't mean it's automatically allowed, right? There's a million other laws. And so one of the challenges in my legal practice at this point is I have clients who, learn that they're not subject to HIPAA and they think, oh, I can do anything I want. No. There's lots of other requirements. So what you're going to fall into very quickly are the employment laws. I can't ask you today if you're pregnant or about, you're interested in being, getting pregnant. Not a Dobbs issue. That's just I can't discriminate against that. So there's lots of discrimination issues, but they're not privacy issues, and they're certainly not HIPAA issues. They're sort of conceived of civil rights issues. That's one of the critical public policy choices we have today when we're thinking about a national privacy law. Is our national privacy law going to regulate things like discriminatory use of artificial intelligence? We should absolutely regulate discriminatory use of artificial intelligence. it's not at all clear to me that that's a privacy issue. It's traditionally been a civil rights issue or a something else issue. I'm not sure, for example, I use this with my teach at American University, I use this with my students there. Imagine that AU wants to build an AI model based on their last 10 years of students, their applications, their performance in law school, their jobs afterwards, and they want to build a model so they can figure out who's going to get admitted next year. Do the last 10 years of students have a privacy interest in saying, don't include my data in that study? I'm not sure what that is. The last 10 years of students clearly are not going to have any of that information applied to them because they all applied before. They're not applying again. You totally want to make sure that that formula doesn't discriminate against whatever group, anybody. I'm not sure it's a privacy issue. So we're thinking about that. As we have a national privacy law, are there going to be issues about those AI contexts in the national privacy law? Yes.
Are hospitals obligated to hand over the medical records if someone signs off on the HIPAA release?
Someone being the patient?
Yes.
So all right, so that's an important issue. One of the debates that's been evolving over the last few years is what are the patient's rights to dictate, to access, to get control of their own records, get copies of their own records. So if I'm the patient and I go to the hospital and I say, hospital, here's an authorization that I have signed saying I want you to send my medical records to this reporter, the hospital absolutely has to do that. 100% has to do that. One of the complications we're seeing isn't as easy as that one, perhaps. Not easy, but that's straightforward. Patient says, I want to have a copy of my medical records. I have a complicated disease and I'm moving to a new city. I want to get a copy of my medical records. Hospital and doctor and pharmacy, who use all of them, send my medical records to my Apple Watch. Now, there's a public policy choice there because, as I gather, learned yesterday, we'll talk about today, Apple Watch is not subject to HIPAA. So when those records leave the hospital or the pharmacy and go to you on your Apple Watch, they're no longer protected by the HIPAA rules. We could make that easier for patients to get access to their records, or we could say we don't want that to happen when the result is loss of HIPAA protection. The policy choices that we've made so far have favored access over security of those records. So if you're a patient and you want to hold those records on your Apple Watch, you are allowed to do that. And the hospital can't say, boy, you really shouldn't do that because it's bad for your security. But that's a public policy choice that we made. And it's a choice that we have to think about because the HIPAA rules don't apply everywhere. And that would be an example where the records had HIPAA protections when the hospital held it, but those protections are lost when it moves to the Apple Watch that you control as a consumer.
How does that apply to things like apps that hospitals use? I mean, I'm thinking about the major hospitals that I've dealt with in New York City. They require you almost to use their apps to get test results, to make appointments. Pretty much all your personal information's there.
Yeah. So welcome to my job. All right. So you'd go through an analysis in that situation. With the Apple Watch, let me use the Apple Watch as an example, and then I'll go answer your question directly. So if you want an Apple Watch today, you go to the Apple Store. You go online, you order an Apple Watch. The doctor has nothing to do with that. The fact that it can take medical information and the fact that you can choose to interact with your doctor through the Apple Watch is your choice and has nothing to do with the doctor. Apple has a version of the Apple Watch that it created in partnership with Aetna, insurance company. And it's basically what you're describing. Aetna uses it that's how you get access to the patient portal. You get prompts from Aetna when you've got an opportunity to use some claims dollars, whatever it is. They get reminders. That's a partnership where they created that for Aetna to use with Aetna insurers. So in that situation, I would argue that Apple is a business associate, a service provider to Aetna, and therefore is subject to the HIPAA rules for that one situation. So in your example with an app, is the app something that the hospital's using and the app creator is in partnership with the hospital, meaning subject to the HIPAA rules? Or does the hospital say, you need to lose some weight. Here's some apps that might help you do that. Go download whatever you want. If they go download whatever you want, even if based on their recommendation, those weight loss apps are not working for the hospital. So that's a tricky question, and that, again, I have to deal with that all the time. It becomes a strategy issue for some of the apps, right? The app developer in that context, you got to think about who your customer is. If my customer is the consumer, I probably don't have to worry about HIPAA. But as soon as the hospital calls and says, I'd like to buy 1 million of them, yeah, now you're now you got to worry about HIPAA. So that's part of the complication where my issues get into play, and as a strategy issue, as a compliance issue, data segregation issues. Can you combine data from your HIPAA covered apps and your non-HIPAA apps? So a lot of complications there because of how the law works. Yes.
I've seen a lot of doctors in their offices, they've brought in third party, so business associates that like you fill it out as part of like, why are you here in the visit? And then if you read the terms and conditions, they talk about this not actually being medical data. So I'm curious, in HIPAA, are there provisions for medical data or carve outs for medical data? So it might be like, why are you seeing the doctor today? And that doesn't count. And then they sell that data to people for advertising, like of drugs and that sort of thing.
Yeah, I mean, lots of complicated points there. I suspect the exact thing you described is probably not happening, or if it's happening, it's not legal. Let's talk through how that would work. So, first of all, this gets a little complicated when you look at definitions, but my personal opinion, which it's not a unique personal opinion, I think it's the consensus opinion, is if a doctor or a hospital or a health insurer has information about you because you are their patient or you are their insured, it doesn't matter whether that information is about your diabetes or your heart rate, anything about you that they have because you're a patient is protected by the HIPAA rules. Again, we could debate that a little bit, but for example, if the hospital has a list of patients, they have the name and address of all the patients who enter their hospital, HIPAA does not allow them to take that list with nothing else and sell it to somebody. So I think that means that when they have your name and address doesn't say anything about your health, obviously. Perhaps not obviously, but presumably doesn't say anything about your health, which actually is going to be the next slide, but that's a whole different, so good lead in, thank you for that. I don't know who those people are that are coming in to do those surveys. You know, there may be ways you can anonymize the information so that it's, you know, if I want to understand, you know, I use Sibley Hospital in DC that my family uses. Yeah, if Sibley Hospital wants to do a study of who their patients are and where they're coming from, maybe there's a way to do that in a way that they don't really care about you, they care about the aggregate, and so you can anonymize the information. There may be some opportunities to de-identify the information. But in general, I don't know why somebody could come and sit in the waiting room with the permission of the doctor and collect information from you and say it's not HIPAA information. Right, but that should be part of that. If what you're doing is it's an electronic version of what you would fill out on paper, that absolutely should be subject to HIPAA rules. Maybe somebody's not doing that right. Absolutely. Yes.
I'm curious about artificial intelligence and like training.
I'm very curious about artificial intelligence.
The training of, you know, algorithms
Yep.
requires a lot of data.
Yep.
How does that work with medical data, since that is potentially public interest? But
Well, all right, so that's a really good example of how to think about these issues and what some of the key challenges are. There definitely are people who would like to see the HIPAA rules actually be more permissive for certain kinds of research and analytics possibilities because of that public interest that, you know, everyone in this room, whether you think about it for yourself or not, has an interest in good medical research going forward. You may not know about it now, but it may, you know, so there are some issues there. A hospital, as an example, can do anything it wants with the data that it has to build models, to build algorithms, to learn lessons from that. No question about that. The hospital can hire a vendor to help them with that job. When they hire the vendor, they have to have a contract with them, and the vendor is limited on what they can do with the information. The hospital cannot generally, I mean, you could get permission of every single patient, that won't ever happen. Hospital can't sell that data to somebody who wants to build a great algorithm. There may be slightly easier ways for the hospital to disclose information to an academic researcher without the need to get patient consent, but there are very particular rules on when you do and don't need specific patient consent for research. Complicated, There are absolutely people who think that the research provisions of HIPAA are impeding medical research. I am not one of them, but I understand the argument because I do think the rules are complicated. But that's a perfect choice, right? Is where there's a public interest in medical research, and it's not just a industry interest, it's every consumer has an interest in that, even if it's not specific to your information or your current situation. So we have to figure out how to design privacy rules. You could make it much harder, you say no data of mine can ever be used for research without my specific permission in a specific example. That probably goes too far. That gives you more protections as a consumer that you may not really be any benefit to you, and there's a detriment to society. But that thinking, again, we need to go through that thinking in the healthcare setting much more than in the retail setting or banking setting or other kinds of settings. Yeah, go ahead.
And follow-up question to that: does HIPAA actually say anything about de-anonymize or anonymization?
Absolutely, absolutely. That's another good example. When I have more time, I use that example with my classes. But so basically, there's a standard to what's called de-identify information in the HIPAA rules. HHS very explicitly said we could make it harder to de-identify information. We could go from tiny risk to the consumer to no risk to the consumer that your information can be re-identified. But going from tiny risk to no risk gives you a little tiny bit of extra protection, but not very much. And going from tiny risk to no risk means we can't use that data for all kinds of good public health and research purposes. We're not going to make that choice. So they came up with a standard that is really good protection for privacy and allows data to be used for those purposes, rather than perfect protection where we wouldn't be able to use data for those purposes. So again, a very explicit, conscious choice. Tell you a point for this is a very important point for reporters, because I see reporters actually get this wrong a lot. There are definitely people who think that the HIPAA standard on de-identification is too permissive. They will say it's too easy to re-identify that data. You will then hear one story from about 20 years ago where a very sophisticated computer science researcher at Harvard, I think, was able to take a data set from the Massachusetts Public Health Authority, not subject to HIPAA at all, Massachusetts Public Health Authority, and re-identify the medical records of the governor of Massachusetts. The reason that person was able to re-identify the records of the governor of Massachusetts is that the governor of Massachusetts had a heart attack on national television giving a press conference. And so it was very easy to connect the dots between that time and this hospital and that place and this person here. Okay, fine. That happened once in 20 years for a non-HIPAA data set in a weird situation. You can't find an example today of HIPAA de-identified data being re-identified. I'm not saying you won't ever be able to find that. And the rules envision that that might happen. But if it happens once out of a million examples, and many of the million examples were used for research and public health purposes, that's a trade-off that the government explicitly made. You can disagree with that trade-off. I just want you to recognize what that trade-off is. All right, let me keep moving. Let's talk about health information in general. Big issue today. What is health information? Why do we care about it? What's particularly sensitive about it? The HIPAA rules treat all health information the same. So your physical is the same as your HIV records and your pregnancy records and your diabetes records and your cancer records. That's a question, right? There are certain kinds of medical information that all of us would probably say is more sensitive than others. HIPAA rules don't draw that line. Mentioned earlier, your name and address as a patient is protected under the HIPAA rules. That data would not be protected as health information in Europe, for example, because they have a very narrow definition of what's sensitive health data. Your name and address is not on that list. We probably don't care if your name and address is on a list of hospital patients. We do care if your name and address is on a list of HIV clinic patients. So again, it's name and address. It's context matters. I also use foot surgery records. If I break my ankle playing tennis and I need surgery, nobody cares about that other than me. If LeBron James breaks his ankle playing basketball and he's not going to play again in his career and not $90 million he got paid, lots of people care about that. So is that a foot issue? Is it a surgery issue? That seems to lead to a conclusion that says every person gets to decide for themselves, which is exactly what we don't have in the rules. We need to think about that. Then if I went to your home computer or your laptop, probably a laptop, and I searched your browser history and I looked for medical information, is that health information? If you did a search for breast cancer or lung cancer or diabetes, whatever it is, it might be because you have that. Might be because your spouse has that, or your kid, or your parents, or your neighbor, or your friend, or you read something on, But is that health information? If I had a lot of browser histories, I'd probably make some conclusions about that. We're also seeing examples in the healthcare system where all kinds of information that nobody would think of as healthcare information, voting records, purchasing habits, television watching, being used by people in the healthcare system to make healthcare judgments and including it in healthcare research. If you can give me a definition of health information that includes your voting history, how do you do that? But it's clear that that information is relevant for the healthcare system. So that's creating a really challenging issue as we think about healthcare privacy and what the law should say and how we should define healthcare information. So again, I want you to think about those issues. I'm great at coming up with the problems. I'm not sure I have an answer to these questions, but I can look at this and say, we can go in a variety of directions, each of which will have implications. But when we say health information is sensitive, I want to probe on that because, like I said, I don't know that the fact that I went to a doctor for a physical is sensitive. I don't know that my name and address is sensitive, but my name and address is sensitive if it comes out of the psychiatrist. All right? Let's see, I've hit through a bunch of these. I do think this idea of what is outside of HIPAA has been a huge issue and is an exploding and growing issue and will continue to be a challenge. That's all kinds of websites. WebMD is a perfect example. They got all kinds of stuff because you go search for all kinds of detailed medical information on WebMD. Something called personal health records, which are basically electronic filing cabinets for you to have your own information about your own healthcare. None of that's covered by HIPAA because you're in control, but you're in charge of that. Community and patient support groups, the breast cancer patients of Greater Washington. Those exist all over the country for all kinds of conditions. They are very important to consumers. They are very important to patients. None of those are covered by certainly by HIPAA. Probably not covered by any of these laws. Mobile apps in general, again, might have a mobile app that's developed by the hospital for use by the hospital where it's a business associate, but in general, the mobile apps on the App Store are not wearables. And then most of the information that the tech companies have. Google has said for many years that they can identify flu trends faster than the CDC because of search histories. But that's clearly not regulated by HIPAA. You post on your Facebook account, wish me luck, I'm going in for ankle surgery. Not covered by HIPAA, none of that. There may be lots of things that can be done with that data that has relevance for healthcare purposes, but none of it is subject to the HIPAA rule. Here are some examples where this is coming up today. Social determinants of health. We have finally learned in the healthcare system that one of the reasons somebody might be sick is they don't have access to food or they don't have decent housing. But as soon as we start sharing information from the healthcare system to the housing agency or the food bank, that data is going from inside the healthcare system protected by HIPAA to outside the system not protected by HIPAA. There's a pending rulemaking in front of HHS right now that hasn't been resolved, could come out any day, dealing with what are providers allowed to disclose without the patient's permission. The tricky issue, right? You can understand why it might be beneficial to disclose some of that information, but if you're doing it over the objection or without the permission of the patient, that creates its own problem. But it's part of a choice there. Patient access to health information I mentioned, we have favored patient access over security where those choices have come up. Medical research, talked about a question over here with artificial intelligence. Should we be generating more patient information, allowing more patient information to be used for medical research, particularly data research? There are rules, many of you are probably familiar with the common rule, which regulates, it's called informed consent. The idea is if you're going to have a drug stuck in your body, you have a right to know what might happen. Totally makes sense. Those interests, something might happen to your body, may not matter as much if all we're talking about is retrospective data. But we sort of treat it the same right now. We're thinking about should we change those rules a little bit. We do have lots of situations where data is moving from inside HIPAA in permitted ways to being outside HIPAA. We have the reverse. Your voting records and purchasing habits is data that's outside of HIPAA being moved into HIPAA. COVID issues in general have exacerbated all of these concerns. You know, when I started doing legal work related to COVID, the first 429 questions I got was, I need to disclose, what can I disclose about my employee who tested positive in the very early days of the pandemic? Isn't that a HIPAA violation? The answer every single time was no, it's not a HIPAA violation. Doesn't mean you can just like post it in the newspaper. You still had to be thoughtful, and there were other principles, but HIPAA had nothing to do with when an employee tells you they tested positive, what you then as an employer do with that. And COVID has also, aside from generating all this employer data that's not regulated by HIPAA, COVID has also created this weird idea where, again, if you go to the doctor, you and the doctor care about your information. You go to the Gap and buy jeans, the Gap and you both care. But all of a sudden, everyone in this room cares about my COVID information. We don't have rules that really anticipate that very much. So that's been a challenge. Now we obviously have Dobbs superimposed on top of that, creating all kinds of issues. Let me give you one Dobbs example that's specific to HIPAA. HIPAA has a provision as part of the priority, national priority purposes, that allows a hospital to disclose information in connection with certain kinds of criminal activity. The example that I've used prior to Dobbs was patient assaults a nurse. You don't want the privacy rules to get in the way of being able to report the patient who assaults the nurse. Same provision might now be used by someone in the hospital to report somebody who's getting an abortion that might be illegal in the state. And so people are saying, get rid of that provision. I'm like, fine, get rid of that provision, but then I can't report the patient who assaults the nurse. So it's not as easy as that. You just got to think through these things, and I think that's a challenge now. So Dobbs is dominating privacy discussions. Again, the discussion for people regulated by HIPAA is, how do the HIPAA rules apply to that? There's a history, there's a way that works. You know, if a law enforcement agency subpoenas the hospital medical records, there's a process for that. There's hoops that everybody has to jump through, and there's the ways you can produce, and there's ways you can fight the production. Administration has come out with some guidance basically trying to give hospitals support for objecting to those subpoenas. They aren't perfect, but there are ways you can object. We're also dealing with, again, another example, it's not a HIPAA example for the most part. You have employers who have said, we're going to support our employees and provide coverage and support for patients and our employees who are in states where abortion isn't permitted. We're going to get them to other states that are going to have their benefits. Lovely idea, hard to execute, complicated to execute. Are you going to have to go into your HR person and say, hi, I'd like to travel to Michigan for an abortion next week? I'm not sure you want, I'm not sure the employer wants that. I'm not sure you want to go through that, all of that stuff. So it's creating a thought process around all of these new issues. Again, that's a lot of my job these days, is helping companies sort of think through what they're trying to do here. Admirable goal, legal complications. How can you set it up in a way that's going to be protective for the individuals and not get, you don't want to cause new problems for the employer. So, a couple of other points. These issues are coming up in state and federal law. Anybody here from California? All right. California residents, today, under California law, your healthcare information is protected by at least 6 different sets of rules. HIPAA. If it's HIPAA, it's not subject to the California Consumer Privacy Act, which is a new state privacy law. There is a state medical privacy law in California. I threaten my healthcare privacy students at AU, if it's the end of the semester and I don't like them, their final exam is going to be, here's the California medical privacy law, tell me what the hell it means. And it's almost incomprehensible. But if it's covered by that law, it's not covered by the privacy rule. Common rule for medical research, covered by that provision, not covered by CCPA. Then you have CCPA, which covers things like medical apps and stuff like that. But CCPA doesn't cover nonprofits at all, so the community support groups, for example, aren't covered. And CCPA generally hasn't covered employer information, employer-employee information. That's changing in January. But as of today, there are 6 different sets of rules for your healthcare information. That is insane for patients to be able to figure that out. No chance you can figure that out. Very little chance that businesses can figure that out. So it's complicated. And my personal view is there's no upside to complication. One of the lines I use is that the current state of U.S. privacy law today is bad for consumers, mostly bad for businesses, and only good for me. But, lawyer job security is not a public policy goal for the most part, but it's just too complicated. But then we have to think about some of these healthcare issues, and, a general law like we have in Europe that protects all data. In Europe, more of your data is protected, but all that nuance that I talked about for the healthcare system, none of that exists in the European structure. So it's a trade-off. General coverage, somewhat more consistency. Trade-off is we don't have the subtlety and the nuance for things like the healthcare system that's important. So we're thinking about this with the national privacy law. You should watch that if any of you cover legislative issues. I can tell you that the position of the healthcare industry today, for the most part as a lobbying position, has been, we have HIPAA, leave us alone. So the healthcare today is not actually being thought about in any sophisticated way in the U.S. national privacy law debate. At a minimum, we're going to end up with two standards, HIPAA and everything else. But there's just very little thought being given to it right now. So you have people who are not core healthcare industry being the ones who are talking about how to deal with it in national law. So I think that's my last slide. I'm happy to cover anything you want. I talked about today, didn't talk about today. Yes.
Could you talk a little bit more about some of you mentioned the opioids and the substance use disorder issue, because I know that that's a whole different can of worms.
And that's part of this current rulemaking proceeding.
Yes, so I kind of wanted to know more about that. I guess I understand that, if you use some sort of app, if I use like an NA app or an AA app, that's not covered at all because that's separate. But why isn't it kind of aligned with HIPAA already?
Well, so here's the issue. Yeah, here's the exact issue that's subject to the rulemaking. The last administration believed that part of the driver of the opioid crisis was a lack of information being sent to families and caregivers and religious organizations, people like that. So there's a pending rulemaking that the last administration pushed that would allow much more disclosure of information about opioid patients by their doctors to families and caregivers and other organizations. In the rulemaking proceeding, all the families and caregivers submitted comments saying, please do this. We had our loved ones passed away because we didn't know. If we had only known, we could have helped it. And all the consumer groups said, please don't do this. We want, So it's a core tension. It's a core tension. The debate right now is, are we going to expand the ability to disclose that the HIPAA rules permit? Right now, I can disclose if the patient says it's okay normally, like just their family or caregiver. This proposal, if it's implemented, I don't know if it's going to be implemented, would allow the doctors to disclose based on their judgment of whether the family is an appropriate recipient. It's just a choice, right? It's a conscious choice. We can understand both sides of it. It's very stark when you look at the comments, and the families want the information, the people affected don't want to give the information. That's pretty, it's pretty explicit.
But it's just outside of the medical groups. There's not anything for one doctor telling the other doctor.
No, so a doctor is allowed to disclose to another doctor for treatment purposes. They don't have to. They're permitted to. I mean, if I'm a doctor who treated, I'm your general practice physician. If I know you have an opioid condition, might I say I'm going to tell the psychiatrist that, or I'm going to tell the rehab physician? But I may not know, So it's a tricky element there.
I think about in open enrollment, and I remember questions about, do you smoke, do you not?
Yeah.
And if you say you don't, then you pay less.
Yep.
Could that same kind of thing happen for, how much you move in a day or something like that?
Sure. So that's going to be a really interesting issue, and it goes back to the algorithm and the discrimination point, which is, people know that, the hospitals know that, the health insurers know that. That's a fear from a lot of privacy advocates. Today, that's really not an option in most of the healthcare settings, is because we don't have the same kind of underwriting that led to that pre-existing condition concern earlier. But at the same time, it's not illogical, right? I mean, you could easily say, I know if I look in this room and there's 5 of you that smoke and the other ones don't, I know that the smokers historically are going to have a higher healthcare cost over time. It's not irrational to say they should pay more. That's not our current system, and we have, and I understand all of those pieces. So absolutely that's a challenging issue. Some of the concerns, when you hear concerns about AI and discrimination in health insurance in particular, most of those concerns I think are not valid today because the law doesn't allow them to be valid. But if the Affordable Care Act got abandoned, all of a sudden those issues are much more in play. Yes.
Yeah, so when you were talking about Google predicting flu trends, that's an inference that Google is making. And it
Yep.
makes me think about that case a few years ago where Target kind of informed a woman that she was pregnant by sending her coupons for diapers and things like that. And so I'm just
And we're right, by the way. But that's
right. And obviously that takes on a new meaning with Dobbs. And I'm curious, is that an issue that public policy can deal with? Can you regulate inferences that companies are making about?
Well, put it this way, I don't, what Google concludes is that people in Atlanta are asking more about flu trends than people in Cleveland, and they're drawing a conclusion that there's a higher flu rate in Atlanta. They are not, to my knowledge, able to say you have the flu, or even you are, that would mean you're more likely if you live in Atlanta than I would if I live in Cleveland, but it's not any more general, it's not any more specific than that. The Target one, again, people know the Target example. Target example was, they based on certain purchasing habits, it was like a 15-year-old girl, she gets a catalog. Again, she gets the advertising circulator, and the advertising circular had a few more things in it that a pregnant person might be interested in. But it's a prediction, and it happened to be right in this situation. It happened to lead to all these problems because the girl hadn't told her father, and the father, I'm not sure how the father figured it out from this confusing advertising circular, but whatever. But all of those are important. Again, lots of challenges there. I think there are. I actually had a dialogue with somebody on Twitter the other day about, Google's getting hired by a variety of hospitals to do analytics. Lots of people have nervousness about them. The Wall Street Journal had a crazy, the Wall Street Journal was like, oh my God, Google's getting all this information about hospital patients. I'm like, if you hired Kirk's analytics services to do the exact same work, nobody would care. The only reason you care about Google, I think, is if you assume Google's going to break the law. I don't think Google's going to break the law. They know the law very carefully. They're actually very good at building these. So they may be very useful at helping a hospital design better models. Now here's a question for you. If Google has 10 hospital clients, are you going to object if Google wants to combine data of the 10 hospitals so that model's actually better than if they built 10 different models? Anybody have a concern about that? It's a tough one. We have an issue with all these vendors, the mobile apps, or anybody who's building an analytics function. Don't you want that analytics function to work better, to improve over time? You could read the privacy rules to say, no, you're not allowed to do that. That's not working for your client, that's working for you because you're trying to build a better model. I would like a better model. But that's a choice and that's a complication and we have to think through that issue. Yes?
Google stopped doing their flu trends in 2015 because they were terrible at it.
Well, that's a whole different point, right? Is whether the information is accurate.
So is there, HIPAA has the accountability angle, if we're starting to use medical data, do we have a privacy imperative to come back and follow up? And again,
the accountability, by the way, is not anything to do with privacy.
But I'm just thinking about, as we're doing machine learning, do we have, could a company argue, it's against patient privacy for us to audit our algorithm? And they've talked about that. So I don't know.
I do think, again, that's a decent part of my job is, there's, and this is an interesting issue because it's a privacy issue, it's a competitive issue, it's a technology issue, it's a contract issue. There's a whole bunch of permutations of that. One of my general thoughts is I would like the algorithms to be better. If I'm gonna build an algorithm that says you're in the hospital, your risk of getting an infection is much higher if you have these three things, I would like that to be right, and I would like that to improve over time. Again, if my way to build that better algorithm is to post all the hospital patients' information on my public website and hope people call in with, okay, don't do it that way. But if you do it within the rules, I'd rather do it that way. But that's not an automatic choice. And it's that as you get, and there clearly are, here's the example I use with people a lot. If I have a mobile app that's going to diagnose your heart rate, whether it's accelerating, okay, fine. I want that to improve. I think that's good to improve. If I want to take that same technology and use it to diagnose whether you're getting enough exercise, maybe that's close enough. If I want to take that same device and use it to figure out if you're going to be a good tennis player, maybe that's too much of a leap. Using the data is exactly the same. But there's a line there, right? Going from heart rate to calories or to movement may be okay. Going from heart rate to tennis player, we all sort of have a reaction to that, but I'm not sure the privacy issues are any different. Well, you could write legislation, and the HIPAA rules do. I mean, again, in the rules, not the legislation. They have something called data aggregation, which is specifically intended to allow an analytics firm to combine data of 10 customers and use it to build a better model for everyone. That comes up in not underwriting. What's the word? There's a my memory stinks, but I mean there's a pricing model that insurers use. Having more data is always better for that. So there's a way to do that. You don't have to allow that. So that was a conscious choice. If you can write that rule, you can write it into law. So, I'm happy to keep going, but I know you have a schedule, so I don't want to keep.
If there's one last question.
Yes.
Is the California rules on the health apps, and especially with regard to, say, femtech, is that a good model? Are there good models out there? Are there any guardrails, or do you think that the next few years we'll see some coming vis-a-vis, say, like, police, authorities, criminality?
Yeah. I think that, I mean, the Dobbs stuff is going to be really interesting. I don't, the models, I'm not sure what you're going to do with that model. And I don't know, the problem is you've got so many different people interested in the same data for a variety of different purposes. There absolutely are people who are saying the best advice, if you're a woman in that, is not to use those apps. I get that. I totally get that. At the same time, it seems like that's a terrible result. But if you make it impossible for law enforcement to get access to that data, you also make it impossible for law enforcement. You probably also make it impossible for law enforcement to get information about the person who just gunned down people, kids in a school. Now, you could draw a line there, right? You could say only for abortion-related or whatever you want, reproductive health information. Right now, we're dealing with things like location data. My location being here is not sensitive. My location, if I'm in the abortion clinic, is all of a sudden sensitive, but it's just location data. And that location data might be that I'm in the abortion clinic, or I'm in the doctor's office above it, or I'm in the bank on the next door, or I'm in the Panera that's next door. So it's really hard as we think about different kinds of data and different implications. The California healthcare models are difficult. I know they have this new law that we haven't really seen any effect. I hate the California medical privacy law. I think it's a complete mess. Not because they had bad, I can't even figure out what they're trying to do. It's a horribly written law.
I just wanted you to elaborate on that. As a resident of California,
It's a law that applies to many of the same people who are covered by HIPAA. 62% of the law just says HIPAA. I don't know what the point of that is. 18% of the law says something other than HIPAA. I can't tell if that's more or less than HIPAA. It's just different. I don't understand the point of that either. Then you have HIPAA principles applied to people who aren't subject to HIPAA, where those principles don't make any sense. It's very hard to figure out what they're trying to do. So I view that law as a complete mess. I view that law as a reason, I'm not sure this is a sufficient reason, but it is a reason in the national debate to have a national standard rather than let the states do their own thing. Because at least in that example, I think and there's two medical privacy laws. There's one in California, one in Texas. They're both a mess.
how did they get it so wrong?
That's a really good, I don't know the answer to that, because they both are after HIPAA. They both are written by people who clearly knew HIPAA existed. But if you're going to take HIPAA, take it and move it over. Don't edit it. They change words. Sometimes it's stricter, sometimes it's less strict. It's almost nonsense. So listen, I don't want to keep you. You have my contact information. I'm always happy to talk to people. If you have any questions, let me know. Happy to respond. Happy to get on a call. Happy to send an email. Again, I'm interested in doing that. Happy to do it. So thank you for having me today.
Thank you so much.